Rodger Citron, and I'm a professor at Touro University, Jacob D. Fuchsberg Law Center. This is a Touro Law Review podcast. Delighted today, our guest is Professor Pat Connors from Albany Law School, and we will be talking about a subject near and dear to Pat's heart, which is the New York Court of Appeals. Before we jump into the substance of our discussion, Pat, please tell us a little bit about yourself.
Hi, Roger. Thanks for inviting me to this. As I mentioned to you and Alexander just a moment ago, I was a visiting professor at Touro back in the fall of 2015 and really enjoyed the experience, really enjoyed the students. Back in the day when Patty Salkin was the dean, and Patty and I became friends when I joined the faculty at Albany Law School in 2000. So that was a great time in my life. Roger, I think you may know, I grew up in Mineola, which is the county seat for Nassau County. And I went to a school called Chaminade High School, where I got a fantastic education. One of the requirements at Chaminade was you wore a jacket and tie every day, and you had to have your top collar buttoned. And that sort of stayed with me through my teaching days in law school. Then I went on to Georgetown University, where I got an excellent education, had some great mentors there. And then I went to St. John's Law School, and I graduated in 1988. And at St. John's, I became the research assistant for Professor David Siegel, who wrote a book that I have by my side usually. Here it is, the New York Practice Treatise. And that was a great experience for me, where I really learned a lot about civil procedure, New York civil procedure, and the CPLR. And he recommended me for a clerkship with Judge Richard D. Simons. And I ultimately received that clerkship. Judge Simons at the time was on the Court of Appeals, and his chambers were in Rome, New York, in Oneida County. And the court, of course, is in Albany. And it worked on sort of a rotation where we'd be in Albany for 2 weeks at a time. Then we'd go back to Rome, the home chambers, for 3 weeks, and basically draft opinions for cases that we had heard in the prior term, and then prepare for the cases that were coming on the next term. It was a 2-year clerkship, but he asked me to stay on for 3 years, and I was so glad I did that. I learned so much as a clerk. He was a fantastic man. We'll talk about him more later. He passed away this summer, but just a great judge and a great judge to clerk for. After my clerkship, I decided to stay upstate, Roger. I thought about coming. I always thought when I moved up in 1988 that I would move back down after the clerkship was over. But I really enjoyed life in central New York and upstate New York. So I decided to stay, and I practiced law at a firm called Hancock and Estabrook, based in Syracuse, New York. And I was an associate, and then I became a partner at the firm. That was a great place to work too. I got a lot of on the ground experience in court, dealing with clients. And I did that for 9 years. And while I was doing that, I became the adjunct professor at Syracuse University College of Law, where I taught professional responsibility. And I did that for 11 semesters while I was practicing. Made for a busy schedule, but I really learned a lot about teaching. I then applied for a position in 2000 at Albany Law School, a full-time position. And I received the position and ultimately became tenure. And now I am a chaired professor of law at Albany Law School, where I teach New York civil practice and professional responsibility. And I really enjoy my life. I live up in Saratoga Springs, and I go into work every day. It's about 40 or 45 minutes driving down the Northway, but I love it. I love going in, and I love teaching, and I feel blessed really that I'm able to do that. So that's basically, I guess, a thumbnail sketch of what I've done, Roger.
That's great. And one of the compliments I give to students when they graduate is, if they've earned this acclaim, right, you haven't wasted your time here. And really, in your career, I kind of feel the same way. You've done a number of different things. You were in the judiciary as a law clerk. You were in private practice, and you had that experience of working with clients, which is I think, indispensable, to really becoming a complete lawyer. I only had 2 years in private practice. And so I know from, fellow classmates and so on that that's really where the rubber meets the road in certain ways. That is, it's at the heart of law practice, working with clients. And then, of course, you've been teaching now for more than 2 decades. So you've done it all. Can I ask one just quick follow-up, which is that when you took the position at Albany, was it with the understanding or intention on your part that you were going to be the New York civil practice guy, if I can say it that way?
Oh yeah, the position, Roger, and I think this is unique in academia today. The position was primarily for New York civil practice. I always tell my students, we have 6 credits in New York civil practice. When I went to St. John's, by the way, it was 8 credits. And I think a great argument could be made, it should be 8 credits still. But we offer 6 credits. And I tell my students, nobody in the world can get more than 6 credits in New York practice. So at the time, Roger, in 2000, we had a professor, a fine professor, Professor Bob Barker, and he taught evidence, and he writes a great book with Professor Alexander from St. John's on evidence, comparing state evidence rules and the federal rules of evidence. And Professor Barker was going on basically, retired status. And that meant he was out of New York practice. Professor Siegel at the time was, in his late 60s, and the school said, we need to have somebody come in, not so much to fill Professor Siegel's shoes now, but to fill Professor Barker's shoes, because we taught 2 sections. So I was brought in primarily for New York practice, but because of my professional responsibility background, I also was able to serve in that role. And then Professor Siegel, now when I got to the school, this is amazing, really. We had classes about 250, 300. The New York practice class, I had over 100 people in my section, and Professor Siegel had over 100 people in his section. And some people that know Professor Siegel would appreciate this. I can remember I'm sitting here in my house, getting ready to go into school for the very first day. And I'm going to teach New York practice, and Siegel's going to be teaching the other section. So my wife says, you're a little nervous? I said, yeah, I'm a little nervous. And she says, I got to tell you, my wife's a lawyer. She went to Fordham Law School. She says, I got to tell you, if I'm registering for classes and I got a choice to pick between Connors or Siegel for New York practice, I'm picking Siegel. So anyway, I had a small class that year, 40 students, but then it grew, and we had both in New York practice 1, which is 3 credits, and New York practice 2, which is 3 credits. We had basically 100 students in each of the sections.
Well, my immediate reaction is that's a lot of exams to grade.
Oh yeah.
so God bless you. Yeah. And then how long did because it really must have been wonderful to be a colleague of Professor Siegel's while coming in and teaching the course, like getting up and running in teaching a course that is really, I mean, yes, 6 credits. It's easily a 6-credit course.
Yeah. Oh, it was great, Roger. I said before, I had many great mentors in my life. And, for Alexandra on the podcast here and other students, look for those mentors in school. And when you get into practice, it really makes a difference. And, he gave me great guidance when I was at St. John's. He helped me get the clerkship. And, the thing with Professor Siegel, when he recommended you for something like the clerkship with Judge Simons, I was afraid that, I was going to make a mistake and Judge Simons would be disappointed. But I was much more afraid that if I made a mistake, Professor Siegel would find out about it and he would really come down on me. And then we stayed in close contact when I was in the law firm, practicing 9 years, and he would send me oftentimes his drafts to review, and I'd make recommendations. And then when we taught together, it was a fantastic experience. And he really helped me, emphasize that you can't go into a course like New York practice and talk about your baby subject, Article 16, and let that monopolize the schedule and the curriculum. You have to, it's a survey and you really have to hit everything across the board. And I thought he did a great job with that in his classes, and he's done a great job with it in the book. And it was great. Yeah, we taught together for 6 years and did review sessions. Another thing we did, Roger, and we would often go down to Long Island for this. We did it oftentimes in the Huntington Hotel in Melville. And we did a lot of CLE programs together. And it was almost like for, the old school, the Huntley and Brinkley, and there was some back and forth, that I think the audience enjoyed. They were really there to see him, but it was a nice way for me to, meet the audience and contribute to the extent I could. I just I came back from Suffolk County about a month ago doing a program at the Suffolk County Bar Association. So it was a great time we had together, a great mentorship, and he still lives with me today when I'm doing my work.
Mm-hmm. And then since we're talking about the New York Court of Appeals, we've talked about it a little bit so far. Can you, to the extent that if there is more of your professional or academic experience, with respect to the Court of Appeals that we haven't covered yet, can you just tell us a little bit more if there's more to say?
Well, since my clerkship, I did argue one case in the Court of Appeals during my practice, and it was a prisoner that won on a pro se appeal. He won his appeal to, I believe it was the Second Department, and then the DA was appealing it to the Court of Appeals, and I got the case as assigned counsel. And unfortunately, I lost the case. I always felt bad about that. Here, the prisoner was pro se. He wins the appellate division. I lose in the Court of Appeals. But that was a lot of fun to go up and argue that case. I've also, since that time, now in academia, I follow the court very closely because I need to know what they're saying about civil procedure. I need to know what they're saying about professional responsibility. My primary area of writing is in civil procedure. And they do typically, even though their caseload has gone down rather dramatically, they still issue a lot of opinions on civil procedure. So it's important for me to review those. What's nice too, they have an appellate judges seminar on an annual basis. They've missed a few years with COVID, but I've been able to present at that, which has been a lot of fun. And then the third department, which is located in Albany, just down the block from the Court of Appeals. And the Court of Appeals has a CLE program together every year that I present at in New York practice. So the judges usually don't come to that, but the law clerks do. And they have a lot to say, and I can learn a lot from them when I'm going through the various case law and statutory developments.
Yeah, and so, no, that's, I'm sure it's vital for you to sort of be in contact, be in touch, and be around. And it's great that you have so many opportunities to do that.
Yeah. And one other thing, Roger, and just a shout out to Evan Krinick with Rivkin Radler that I know. I believe he's on the board of trustees of Toro's Law School, or he was at one time. And Evan clerked at the Court of Appeals. And he does an article, and I do an article in a publication every year with the Law Journal called the Court of Appeals Year in Review. So Evan takes all the insurance cases and summarizes the developments and notes their importance. And I used to do the professional responsibility, ethics, judicial conduct part of that. Professor Siegel would do the New York practice part of it. And of the last, I'd say 15 years now, I've done the New York practice aspect of that, where I summarize the annual, summary of the Court of Appeals case law and how they might impact lawyers practicing in the state.
Yes. We may come back to that, because that is something that, especially early on in my teaching days, I remember those were really, it's like a thick insert, if I remember correctly,
Yes.
or it was in the paper edition of the Law Journal.
Yeah.
And it was very informative. But if we're going to talk about the Court of Appeals, I mean, maybe one way to come into it would be, because one of the reasons why I wanted to talk to you was I feel like the New York Court of Appeals, state courts generally, may get short shrift in law school. And so for those who may not recall much about the New York Court of Appeals after orientation, can we just sort of come into it by saying, what's the court's mandate or role or function? How would you, the shorthand thing that we say in orientation is, well, the New York Court of Appeals is like the US Supreme Court for the state of New York. And that's probably accurate as far as it goes, but I suspect that you would elaborate on that description.
I think you're right, Roger. It does get short shrift. I think state courts get short shrift. The Court of Appeals, the appellate division gets short shrift in law school. Many reasons for that. Just tell you a funny story. Former Chief Judge Kay, who was, again, a fantastic mentor to me, even though I didn't clerk for her. I stayed in close contact with her after my clerkship, and she was an unbelievable woman and a very fine chief judge. I remember she telling stories about going to law school events and maybe participating in a moot court. And the law students are, putting this together and organizing it. And they have her like sitting on the level with the district court judges in the federal system. And meanwhile, she should at least be with the Court of Appeals. The Second Circuit judges are probably higher. So anyway, I think the state courts do get short shrift in law school, and hopefully that will change because their impact is very important. The New York Court of Appeals, I think really you could say it's the Supreme Court. Roger, I think it's more important probably than the United States Supreme Court for the citizens of our state as far as the impact it has on our day-to-day lives. There are big issues that go to the United States Supreme Court, but I think overall, the New York Court of Appeals and its rulings, and sometimes they'll rule on something that doesn't get before the Supreme Court, and it will govern, even though it could go up there someday. That New York Court of Appeals has a much greater impact on the lives of the citizens of New York, and most certainly its jurisprudence has more impact on the practicing bar within New York. I guess a couple of things. If we have a New York State statute, and there's so many of them, general obligations law statute, and it prohibits, for example, healthcare facilities from requiring that patients arbitrate any claims of medical malpractice. Well, the New York State Court of Appeals has the final say on what that statute says. The Supreme Court can't tell the Court of Appeals what that statute means. But you have a situation in that area where the Court of Appeals might say, this is what the statute means, and this is how it should be applied. And the Supreme Court could say, well, that interferes with arbitration under the Federal Arbitration Act. And then the Federal Arbitration Act preempts the statute in that area. So that's a decent example of the interplay between the Court of Appeals and the United States Supreme Court. One other interesting issue for lawyers, there was a woman named Mrs. Schoenfeld, and she was a New York lawyer. She passed the New York bar, and she was admitted to practice in New York. But her law office was in Princeton, New Jersey. And there is a statute, Judiciary Law 470, which says if you're a non-resident New York attorney, you have to have an office in New York State. So Roger, you're a resident of New York State. I'm a resident of New York State. We don't have to have an office to practice law in New York. But Mrs. Schoenfeld did, because she resided in New Jersey, didn't have a New York residence. She challenged that statute, and she said, it's unconstitutional, and it violates my rights under the Privileges and Immunities Clause. So she brought a proceeding in federal court, and Judge Kahn, the district court judge, said the statute's unconstitutional. Goes up on appeal to the Second Circuit, and the Second Circuit says, we're really not sure what this statute means. What does it require? Do you have to have bricks and mortar? Can you simply have a mailing address? Can you simply have office space somewhere in New York? So they sent what's called a certified question to the New York Court of Appeals and said, please tell us what your statute means. Tell us what Judiciary Law 470 means. And the court basically said, this is former Chief Judge Littman, said it means bricks and mortar. You got to have a bricks and mortar office here to comply with the statute. Now, they didn't reach the ultimate question about whether it was constitutional. They just said, here's the way we interpret the statute. They sent it back to the Second Circuit, and now the Second Circuit decides whether that application of the statute or construction of the statute would be constitutional. I think the Second Circuit surprised everybody and said, yes, it's constitutional. And that's a nice example of the interplay. New York Court of Appeals has the final word on what Judiciary Law 470 means, but as far as its constitutionality, that could be challenged in another court. And Roger, that's another unique thing that we have in New York, where the Second Circuit, it's actually any of the courts of appeals throughout the country, federal courts of appeals, the United States Supreme Court, or the highest court of a state can certify a question to the New York Court of Appeals to say, tell us what the answer to this is under New York law. And then when you give us the answer, well, when you have the answer complete, send your determination back to us. We will apply it in our case and rule on that. And that's been a busy source of the court's business lately. And that came through, I think, in 1986, that provision. And former Chief Judge Wackler, who I believe, is he still teaching at Toro?
I don't think he's teaching this semester. I know I'm virtually certain he taught last year.
Yeah, another amazing guy. I mean, he's had a troubled life in many ways, but in Nassau County, we called him the Jewish JFK. I mean, really, he has amazing charisma. But that was a proposal that came up under his time as a chief judge, and it's unique, I think, in the country.
Yeah, I have to throw in if any of my civil procedure students are listening, remember this last exchange about the certification procedure when we get to Erie Doctrine. When we get to Erie Doctrine, because New York does have this statute, not every state does, and that's where, even in the first year course, in the first semester, since we do Erie in the first semester, that's where we would do this. And also, yes, as to Judge Wackler, I think I've had the conversation with him, and I know he's written things for the New York Law Journal and perhaps even law reviews. I know I've read him talking about the idea of, where did it come from and why it was necessary to have this certification procedure available. And it works exactly as you said. You're not deciding the case. You're saying this is what the law in New York is, or you're giving the Court of Appeals the opportunity to say what the law is.
Because it's funny, Roger, when the process started, it started off well, but then there were a few certified questions that the court rejected. And I think the Second Circuit got a little bit upset. I'm sure Judge Wackler will remember that. But I think it's calmed down a bit now. And although I think recently they rejected a certified question, they don't have to accept them.
Yes, I think that the idea of discretionary review, in the same way that the U.S. Supreme Court, right, you file a cert petition, 9 times out of 10, or whatever the numbers are, it gets denied, right? I know we're talking about a specific aspect of the certification procedure, but just to note that the New York Court of Appeals also has discretion to decide which cases to hear, not just with respect to certification, but other types of appeals too.
Yeah.
And this is one that, because I'm a history buff, as Alexandra can tell you from the other podcast. I can't help myself. I'd love for you to just it's a court with a rich history, and who are some of the extraordinary judges that even our law students in the first year, they will start to learn the names and some of the decisions of some of the judges who have served on the Court of Appeals. It's kind of like maybe we won't do a top 10, but maybe just a couple of the more interesting or distinguished judges who served on the court, in your opinion.
Oh yeah, there's so many, and it is such a rich history. And I would just say not only the judges, but the jurisprudence of the court is so interesting. And I always said, if you put me on a desert island and you said you could have one court reporter with you, I would definitely take a New York second, New York third court reporter as opposed to a federal second or federal third, because the jurisprudence of the Court of Appeals is so interesting. And of course, you've got Judge Cardozo. I always will trace things back, being in Saratoga Springs and being a horse racing fan, we often will trace back the pedigree of the horse, the lineage, and we have Bold Ruler maybe and Secretariat, et cetera. And we have the same thing in New York, where we can trace back doctrines all the way back maybe to the Cardozo era. And it's funny, recently, two big ones were overturned in Daimler, the most pro-corporation decision I've seen out of the United States Supreme Court, written by former Judge Ginsburg, and very pro-corporation. Won't get into the details of that, Roger, but that really overruled the Cardozo principle that a company that's in New York doing business on a regular basis is subject to general jurisdiction. That's the Tauza case. And that was overruled by Justice Ruth Bader Ginsburg and 7 of her colleagues in Daimler. And then you had Justice Sotomayor concur. We also had a case recently in the Court of Appeals on whether, when a Delaware corporation registers with the Secretary of State to get a license to do business in New York, is that a consent to general jurisdiction in New York? And Chief Judge Cardozo had said many years ago, about 100 years ago, that yes, it was. And that line of cases was recently overturned in a case called A-Bar, which was issued last October. Some of my, Cardozo's up there. Then you had a great line of chief judges with Judge Stanley Fold. And apparently the story of Judge Fold would be, he'd sit on the bench. He's very bright. He'd sit on the bench and he'd ask questions, but he could multitask, right? And he'd have his mail and he'd be taking the mail and putting stamps on his mail. And, right in front of the lawyers arguing the cases, and he's dealing with his mail. Then you had, after Judge Fold, and Judge Fold, the way he wrote his opinions, apparently, he would write things on paper, little slips of paper, and they would organize it sort of on his desk. And then he'd have his secretary come in and type it all up and put it into an opinion. Judge Brightel, Chief Judge Brightel, was an amazing judge. Apparently, his recall on the record was amazing. And you might get a kick out of this, Roger, a great story. In the Court of Appeals, the judges sit there and there's windows looking towards the Hudson River. And he would often listen to the lawyers, and, he was intimidating. He'd be sitting there looking out at the windows and the lawyers arguing. And I remember this story was his case, and he said, "Counselor, can you give us a citation to support that position?" So the lawyer starts giving citations from federal courts, federal second. And he says one case, the Simmons case, F second, and Brightel said, "Not binding." He gave him like 3 cases in the federal courts, and each one, Brightel's just looking out the window saying, "Not binding, not binding." And he was just an amazing judge. His opinions were great. Then we had a Judge Cook. I don't know that he was a favorite of many judges that worked in the judiciary at the time. He really was in charge of bringing OCA, the Office of Court Administration, into the fore. But his opinions are really well done. They're very well written. And then we've got, of course, former Chief Judge Wackler. Again, his opinions are amazing. Another thing, too, Roger, about him, he had a real presence on the bench. I can remember when I got sworn into the United States Supreme Court and the presence that former Chief Judge Rehnquist had. I mean, the clock turned 10 o'clock. They got on that bench right away, and he was going full force. And I remember Judge Wackler had a great trait that he'd always ask the first question in oral argument. And he also had a great way of bringing humor to the proceedings. And I guess those are, the history of the chief judges. I'll just leave off with Chief Judge Judith Kaye, amazing. A great writer. She actually started her career as a newspaper reporter. And you can see that in her writing. She was a fantastic writer, a great judge. She, was an associate judge for about 10 years. And then when Chief Judge Wackler was forced to resign, Judge Simons acted as an interim chief judge, the acting chief judge, and then Governor Mario Cuomo appointed Chief Judge Judith Kaye as the chief judge. And I think some people felt that Judge Simons maybe should have gotten that spot because he was the most senior judge. But boy, Chief Judge Kaye did a fantastic job, great presence on the bench, and just a fantastic writer. And I teach a lot of her cases, a lot of her decisions in school, and it's a lot of fun to go through them.
Yes, no, it's an interesting recitation, and of the history. I believe that our attorney for this apartment that I am in, which is a co-op, but we own, we don't rent, we own the shares here. The attorney was a Fuld clerk, and so he really, that appreciation of the history as well as the quality of his work. He still, because he got so excited when I said I was a law professor, and we talked about Fuld was extraordinary, but all of these judges really are these chief judges that we've been talking about. Judge Wackler, beautiful writer, really extraordinary writer, among other things.
Really, too, it's funny. I remember Judge Simons telling me this. And by the way, Judge Simons, of course, is a hero of mine. And he became a Supreme Court judge at the age of 35. He just barely made it under the constitutional requirements. And he served about 10 or 12 years in Supreme Court, 10 or 12 years in the appellate division, and then I think 13 years in the Court of Appeals. So he really brought everything to the table as a judge on the court. With Fuld, he was just an amazing guy, a great writer, and a scholar. But Judge Simons, I remember telling me that Fuld and Breitel, a lot of them came out of the DA's office in Manhattan with Dewey. If Dewey got elected president in 48, they would have been on the United States Supreme Court.
Yes.
So, funny, but it was, I guess, yes. It was a benefit to the state of New York to have them on the Court of Appeals.
I have a digression. I'll save it for when we're done with the recording on that point. There's still just a couple questions I want to get into about the Court of Appeals. And one of the things, the current Court of Appeals, you were talking about the docket has, I don't know if shrinked is the right word, but they seem to be deciding fewer cases in recent years, at least compared to prior years. Can you say a little bit more about, if you will, I hope that's an accurate characterization, but sort of, if you will, current trends and issues that the court is, wrestling with, or things going on now that would be relevant to, students are listening to this, the students, the court that they're going to be coming into, when they start to practice, that will be, important for them.
Yeah, let me talk about, it is quite accurate, Roger, that there's been a decrease in the number of cases they've handled, and that's very troublesome. A gentleman named Tom Newman, who is on the Office of Court Administration's CPLR committee. It's the advisory committee to the Office of Court Administration on the CPLR. I'm on the committee. Tom Newman's been on it a long time, and he's a prominent appellate lawyer. He clerked, I'm going to forget who he clerked for. It might have been Judge Shalepi back in the 60s or maybe the 50s. And he's in his early 90s, Tom. He's an amazing guy. But he wrote an article in the Albany Law Review recently published, and he tracks the numbers. I just did this morning, Roger. I took a look. When I was there clerking in 88 through 91, during our October term, the court had oral argument 8 days, and then had a day of sitting. And Chief Judge Wackler will be able to remember all this. So it was 8 days of cases, and then a day of basically where they sat and had a consultation meeting on the last day to decide how votes on cases were going to go and who was going to write what. I think I couldn't look this up with certainty. I think we had 50 cases that we heard in typical October. This October, the court met not 8 days, 3 days, and they had a total of 8 cases. Now, Tom Newman tracks all this, but that's a dramatic decrease. We had days, I remember, where we had 8 cases on in a day. And I remember this because that meant that if your judge drew first that day, you were taking 2 cases because there's 7 judges on the court, and your judge would draw first, and then they would draw the 7th case, and the 8th case would go back to your judge. And Judge Wackler could talk about this too. They go off the bench after argument, and there's index cards that are upside down, and the judges basically pick. And they'll look at the card and say, this is the case that they're assigned to report on. November, Roger, coming up this November, 3 days, a total of 8 cases. When I was there, it was 7 days. And I remember they conferenced the Wednesday before Thanksgiving, 7 days and approximately 45 cases. So it's a dramatic decrease. As a result of that, we have many issues of New York law that are not getting resolved, where the appellate division is really the court of last resort. And what that means is the appellate division 2nd department, which governs in Suffolk and Nassau, can come to a different conclusion than the appellate division 4th department. So that's a problem. What I'm seeing is, because the court obviously did, and this didn't start with Chief Judge D. Fiore, it certainly accelerated the decrease in days in Albany and the decrease of cases that they took. It started with Chief Judge Lippman. But what you're seeing is a lot of the court's calendar now is certified cases because the Second Circuit sends them over. But when it comes to lawyers applying for leave, and you mentioned earlier, it's hard to get to the Court of Appeals. I think the chances are less than 5%. And Alexandra, get ready for that question in practice from the client. I always tell my students, 2 questions. We lost at the appellate division. Okay. You'll say, well, we have a chance to try to get the Court of Appeals to hear the case. I'm going to ask for leave. 2 questions. Number 1, what's our success rate? What are the chances of success of getting up there? And 2, how much is it going to cost? And those are 2 tough questions that the clients will always give you. And it's a very, very small chance of getting the case up there. And if you do get it up there, then it's a question about whether or not you can prevail. But it's a lot of certified cases. I'm seeing a lot of these real estate mortgage-backed securities cases have gone up there. I'm not sure that the principles in those cases are relevant to a general practice, but there's some procedural issues in there that are. Roger, you may remember this. Suffolk County led the league in mortgage foreclosures during the 2015, 2016, we sort of seen all these cases in the system. 62 counties in New York State, Suffolk had the most. And a lot of cases have developed law, mortgage foreclosure cases have developed law and procedure that will be applicable to general practice. Some of those make their way to the court, but again, it's a very small percentage. And they do have a criminal docket. I don't follow that very closely because I'm mostly on the civil side. But I'd say about these 8 cases in October, 8 cases in November, I think at least half of them were criminal cases.
Mm-hmm. Do you do you know why, or any thoughts on why this might be occurring? There's a parallel development that's been, I think, going on for a while in the U.S. Supreme Court, and this may oversimplify, but you know, the judge who I clerked for after law school, he was a federal district court judge in the Eastern District of Pennsylvania in Philadelphia. He clerked on the Supreme Court in the 50s and in the 1950s. And I think that in the US Supreme Court, if you compare the numbers, certainly like the time that he clerked, I think they granted cert or they heard on the merits twice as many cases in the 1950s than say, they have, in recent years. I think the number is like, you could compare like something like 150 to 75, 80, whatever it would be. And, an idea is thrown out about that, which is, well, the current court, it may have a view about sort of, the court's role vis-a-vis the other branches of government. And so, that may be one explanation for why cert is not granted, in the same way now or to the same extent in as many cases as it was in the 1950s. And that's kind of I'm sure there's oversimplification there, but that's sort of how I've heard people talk about the fact that, it's half as many cases before the Supreme Court compared to an earlier era. Any thoughts on what might be going on here with the New York Court of Appeals and the numbers that you're describing?
I've heard that about the United States Supreme Court. I can't speak to why. I just don't have enough knowledge of that. A couple of things, though, Roger, I'd speak to with the New York Court of Appeals. Yeah. I think length of opinions. I think opinions are entirely too long now. When I clerked for Judge Simons, he had 2 law clerks. An associate judge now on the court, many of them have 4 law clerks. That's unnecessary for a number of reasons. And you can see this in the, you pick up, especially on the federal side. I mean, you see these lengthy opinions. When I clerked and before then, you'd oftentimes see cases go, by the way, back then, and this was Judge Wackler changed this. And it's amazing. If you got a 1-judge dissent in the appellate division, you got to the Court of Appeals as of right. So they had way more cases on the calendar back in the 70s and 80s than I had now. But oftentimes what they did was they affirmed on, for example, we are affirming on the opinion of Judge Leon D. Laser at the Appellate Division 2nd Department, somebody I know you're familiar with at Toro, and I worked with very closely on the PJI committee. Amazing man, an amazing judge. They often gave credit like that. And that was a great shot in the arm, I thought, to the Appellate Division, where you're working hard. You're not at the Court of Appeals for whatever reason. It might just be bad luck, right? Or political parties, but you're being recognized. You never see that today. And that would streamline, I think, a lot of the work rather than rewriting the law. So that's one thing. Other thing, Roger, and let's be clear about this. It's not that there's a lack of cases. I had an amicus brief I submitted in a case called Ace that was decided in June. That case, from the filing of the reply brief to oral argument, was 16 months, okay? And that is typical in a lot of these cases. So if the new chief judge comes in and says, we are holding sessions, 2-week sessions, and we're gonna meet, we're going to hear cases on 9 days out of the 10 days during the week, that would at least relieve the backlog in these cases. So it's not like they're not there, but also I think, yeah, you'd need a chief judge that would say, we want to get cases up here where there is a dispute on New York law, a novel issue on New York law, an important question on New York law. There was some reporting during Chief Judge DiFiore's tenure that she had communicated to the appellate divisions, don't send us cases. The appellate division has discretion to send certain cases to the Court of Appeals. And apparently she, at least the report in the law journal was, she had communicated to the appellate divisions, don't send us cases. We know the cases we want to hear. so don't send cases our way. Maybe a walk back from that, and maybe the next chief judge will say, listen, if you're in the appellate division and you see an important question of state law, or there's a conflict on the law between your department and another, please send those cases to us. We need to resolve those issues.
Yeah. Well, this is really interesting, and this sort of sets up, because you referred to the fact that we have an interim chief judge heading the Court of Appeals now. And can you just say a little bit about that current situation in terms of what is going on now to find a permanent, to replace the interim with someone who will be, the next, chief judge serving on the Court of Appeals. Just a little bit about sort of timing and process with respect to the vacancy for the chief judge at the court.
Yeah, Chief Judge D. It's interesting. She announced, I believe, in early July that she was going to resign effective the end of August. I'll just say about Chief Judge Di Fiore, I have a lot of respect for her. I think it's unfortunate her tenure was very short. And, we went through the tracking of former chief judges, right? Going back, Conway, Full, Desmond, Full, Brightel, Cook, Wackler, and Kay, and then you had Littman, Di Fiore. Judge Di Fiore is the only judge, I can't recall a judge that stepped away from the position before they were required to step away at the age of 70. But she had a lot to deal with. And I think she was a very good administrator. The role is two-part: administrator of the court system, but also the chief judge of the Court of Appeals. And I think she did a great job as an administrator. She's got some great opinions on, Facebook, disclosure of Facebook, which I'm sure your students will love, and the Foreman case. And she's got some important decisions in the real estate mortgage-backed securities area. But anyway, she decides to step aside, and now there's a vacuum in the chief judge position. So usually what happens is the court meets and appoints an acting chief judge. When Judge Wackler resigned, and I believe it was 1993, court got together and appointed Judge Simons as the acting chief judge. Right now, there was problems in that process that were reported in the New York Law Journal. Here, they usually appoint the most senior judge as acting chief judge. That would be Judge Rivera. But here, it took a while, and they ultimately appointed Judge Canataro as the acting chief judge. He's only been on the court. He's been on the court for less than 2 years. So that's interesting, but he's got experience as an administrator. He's the acting chief judge. Now, once she announced her resignation, Chief Judge Di Fiore, what happens is and I'll give you the website for this. It's the Commission on Judicial Nomination, cjn.ny.gov, cjn.ny.gov. They basically, the court notifies them of the vacancy, notifies the commission of the vacancy, and then the commission asks for applications for the position. And then they review the applications, they conduct interviews, which I believe they're in the middle of doing now. And then they compile a list of candidates. They forward that list to the governor, and the governor has to choose from that list. Governor can't say, I don't like the people on the list, I'm going to appoint somebody else. So that's the way it works. And Roger, we're in the middle of that process now where the commission is meeting. I think the application deadline was the end of August. And it's interesting, there was rumors that Governor Hochul was trying to move this process along quickly so she could make an appointment before the election. But that's not going to happen. The commission looks like, I think I saw something where their deadline to get a list to the governor is the end of November. But it is interesting because Governor Hochul will have, I think she has to wait 15 days from receipt of the list, and then she has 30 days to appoint. So she will have the opportunity, almost certainly, to appoint our next chief judge. But isn't this interesting? Because you have this commission is formed, I believe it's 12 members. The chief judge appoints 4, the governor appoints 4, you've got the Senate, the head of the Senate appoints 2, the head of the Assembly appoints 2. Well, these acting members were, I think, appointed by Governor Andrew Cuomo, Lord rest his soul, and they were appointed by Chief Judge D. So you have a commission here that's really been put together by prior administrations, but Governor Hochul will have the opportunity to appoint the next chief judge, even though, for example, I mean, the race is apparently tight. If she loses to Lee Zeldin, she gets the chance to appoint the next chief judge, even though she'll be out of office in January.
Yes,
So
yes.
it's really fascinating times.
And it's a great counterpoint just to how the process works here in New York compared to what we see every time there's a Supreme Court nomination, where, you know, it's the president's nomination, and then there's these, you know, increasingly brutal Senate confirmation hearings. This is an interesting way of bringing additional sort of players or voices into the process. Yeah. It's a very interesting contrast to how it works, you know, for the highest court, the U.S. Supreme Court.
Yeah, and it's not nearly as contentious, Roger. I would note, though, I think it's important that once the governor makes a selection, that person does have to be approved by the Senate, the New York Senate. But those are rarely contentious hearings. I think the only one in recent history that was somewhat contentious was the senior associate judge now, Judge Rivera. I think the vote on her was very tight. I think she might have gotten it by 1 or 2 votes. But usually that's not a contentious hearing, and the Senate votes to confirm the governor's choice by a wide margin, unlike what happens in the United States Supreme Court, which I think is very unfortunate, but that's for other people to worry about.
So that's another podcast. And if you're lucky, I want to ask you to do that one. I think that's, you know, I think we've run through it. I want to just reiterate, and then I'll give you the last word. Something that you said early on, which I'm guilty of this. That is the emphasis on federal. I teach federal civil procedure. I teach administrative law, which is essentially, you know, federal law. And so you said something which I know is true, and yet it's easy to lose sight of, which is that day in and day out, the state courts here in New York, the New York Court of Appeals, they matter more for more things, you know, that is the ways in which, you know, our lives are affected, more likely to occur through the New York Court of Appeals than the U.S. Supreme Court, not to diminish the significance of some of the cases that, you know, the court decided last year and that we've talked about, you know, I've talked about with other people on these podcasts, as well as, you know, I think with both of our schools, most of our graduates will practice in New York. And so it's important to understand the New York Court of Appeals, to understand, you know, the CPLR, which of course is at the heart of the New York practice course. So I just want to make sure that anyone listening, if you made it this far, it's been time well spent listening. And then I'll turn it over to you, Pat, for the final word.
Yeah, I think, Roger, as far as administrative law that you teach, there's a lot in New York on that. And, you know, we've got the Article 78 proceeding of the New York practice book, which I now author, starting at section 557 and going on. You'll see a lot on Article 78, which are really special proceedings against administrative agencies. Some great stuff there, Roger. can hearsay come in on an administrative hearing? And can you basically confirm the decision of the administrative body based on hearsay? The court Court of Appeals sees quite a few reviews of Article 78, and there's that great concept. I don't think it's not intuitive, but you have an administrative body that rules in a certain way, and you think, wait a minute, the evidence is much more heavily favoring the other side who lost. Well, when that comes up on review, and the Court of Appeals has said this very frequently recently, that no, you don't look to see where the weight of the evidence is. You just look to see if there's substantial evidence to support the determination. And if there is, even though there's more evidence to the other side, you basically affirm the decision. So that's just a couple of things there, Roger. And I don't know what to add other than it's a very interesting jurisprudence. The court's cases are fascinating. I'm trying to think of a case up there now. Well, there's an interesting case on its way to the court, and it's been fully briefed. And for you baseball fans, it involves a dispute between the Washington Nationals and the Baltimore Orioles. And when they moved the Nationals from Montreal down to Washington, D.C., they moved the team into the backyard of the Baltimore Orioles. When I went to school at Georgetown, we went to Oriole games. That was the home team in Washington. And there was an agreement signed, and there's been disputes. It went to arbitration. And again, New York, we're the arbitration capital of the world. And the Court of Appeals has great jurisprudence on arbitration. So there's a case before the court involving that dispute, which went to arbitration. And guess who the arbitral body was? Major League Baseball. It wasn't the AAA. So the first department, in a fantastic opinion, and let's see, I don't know who's applied for chief judge, but you have Rolando Acosta in the first department, who is the presiding justice of the first department. I don't know if he's applied, but he certainly would be a strong chief judge. He came from the Dominican Republic and went to Columbia undergrad. And Ron Darling, the Mets announcer, who went to Yale, pitched against him. And Rolando Acosta was a great pitcher. And he said, Rolando Acosta was the best pitcher he saw in college baseball. But Rolando Acosta pursued a career in the law. But anyway, he wrote a dissent in the first department. And he basically said, although the parties have chosen Major League Baseball as their arbitral forum, Major League Baseball has proved it cannot be fair. So it needs to be replaced with another arbitral body. And that's one of the questions before the Court of Appeals, which is it's going to be a fascinating case when it's heard. It's been fully briefed, but we'll see what happens with that. And I recommend his opinion. It made some headlines. His dissent in the case, it's called TCR, made some headlines, and it's an interesting read.
That is fascinating. And I said I would give you the last word. Extraordinarily, I'm actually going to stick to that. Thank you so much. Thank you so much. And that's our podcast.
Thank you, Roger. I really enjoyed it.